You're listening to Talking Law on Radio 97. Do you have a legal question that you'd like an answer to? Despina happy to help out. All you need to do is put a few lines together and send it to us. You can do that. The best way to do it is through the website. Go to radio97.com.au. Right at the top there of that page, you'll find a couple of ways to contact us. Send us the info, and Despina happy to answer your questions here on a Thursday morning on Talking Law. radio97.com.au.
Alrighty, so segment 2, we mentioned it right before the break. So the big difference between New South Wales binding death benefit laws compared to the rest of Australia. Despina, you're bringing to light how there's this huge difference that so many people may not know about.
And another reason perhaps not to live in New South Wales.
Yeah.
Well, I didn't say that. I do want to say on the record I'm a blue supporter, so I'm probably going to get, negative and positive issues there in Queensland, New South Wales. Anyway, I've put it out there. So, look, I don't know whether, you should live in New South Wales or not. You said it, I didn't. I think the point to make, and we want to go through this very carefully, is to understand that New South Wales has very unique notional estate laws. Okay, and I want to talk about it within the context of binding death benefit nominations because there was a recent High Court case. Now, we love High Court cases because, a High Court case, to get to the High Court, you've got to actually ask for special leave. You've got to turn up in front before one judge and submit your case, and they either say yes or no. And if you get that special leave granted, then you're before the full bench of the High Court putting forward your case at a later time. So to get to the High Court's always a big deal. We love High Court cases. And this was a case determined on the 15th of June, very recent. And the case is called Hill and Zuda. So people might have seen it come across under the heading of binding death benefit nominations and superannuation death benefits. So that's the name of the case. So the outcome of the High Court case was this, that binding death benefit nominations, which we've talked about on the show before, which means you sign a document called a binding death benefit nomination where you are nominating someone to receive your superannuation death benefit, and you are binding the trustee. So they must follow those provisions and wishes that you've notified the trustee of, and you want that superannuation death benefit to be paid to the beneficiaries that you've nominated. So it doesn't actually form part of your estate. Very, very important there, and distinction to make with estates, and we've talked about that before on the show. So typically with binding death benefit nominations, they will expire in 3 years. They lapse. And then you've got to make sure that they're renewed. And we've talked about that before on the show. This case, the High Court case, has said that that does not apply to self-managed super funds at all. So it was a High Court case to confirm what we already knew, but it's good to have the High Court confirm that these provisions about the 3-year lapsing rule do not apply to self-managed super funds. So very important for people to know that, and I've talked about that only recently on the show. But of course, you should always exercise caution when you're doing binding death benefit nominations, because I also said, yes, but it's got to still be compliant with your trust deed. Okay, so always go see an expert in relation to your superannuation and make sure it is still compliant with your trust deed. Now, the issue about New South Wales is there was another recent case. We love cases.
So many cases.
So many cases. And it was called Benz and Armstrong. So it's a Supreme Court case in New South Wales. Now, what I've said before about binding death benefit nominations, superannuation death benefits, they don't form part of your estate typically. So they won't come into the pool of assets. And if somebody makes a claim against your estate, generally you see that superannuation death benefit won't apply if it's under a binding death benefit nominations, because it's sitting over here. However, New South Wales has these notional estate rules, and they're unique to New South Wales. They don't apply anywhere else in Australia, and that means that it's the ability to treat property not actually part of your estate, like what I just said, as still notionally being part of your estate. So they're actually up for grabs if someone makes a claim.
Wow.
And they're unique to New South Wales. So whether or not you want to live in New South Wales because of this issue, is another point or another topic of discussion perhaps. But the point to make is that they are unique to New South Wales. So even though you've made a binding death benefit nomination and you've said to yourself, okay, I've made it, I've nominated beneficiary X, they're going to take the benefit after I die. It won't come into my estate. The case of Benz and Armstrong says otherwise. And in that case, because of the notional estate rules, the court actually took some of that superannuation death benefit and they actually made it part of the estate.
Wow.
So they actually took it out of, they took it from here and they put it into the estate, despite there being a binding death benefit nomination in place. So despite all of that, right, and what the deceased put in place, the court said, well, we have these notional estate rules. I can use that. There's a claim being made here against the estate. Oh, I'm actually going to take some of the superannuation death benefit out of that and I'm going to put it into the estate. And now it was part of a claim. So that person who made a claim, the asset pool was increased. The value of the estate was increased.
Okay, and
so,
Despina, I guess a lot of people in New South Wales may actually not know that law exists and that those conditions exist.
That's right. And what they also may not know is that assets held jointly, right, they can also form part of these notional estate rules. That's why you have to be really careful in New South Wales. Yeah. So even though you own a property as joint tenants, see the law of survivorship we have, we talked about that before. The first person dies, the second person gets the property automatically at law. Now, New South Wales has these notional estate rules, very unique. So that may not be the case if you own property jointly.
So why do we have such different rules to the rest of the country?
You will have to dig deep back into history as to the establishment of these notional estate rules and how they came about.
And it's nothing recent. It's nothing recent. So we win the origin, but we don't win when it comes to binding death benefits. Thank you once again, Despina, for coming on the show for Talking Law. If anyone does want to get in touch with you directly, where can they go?
So they can phone the office 55 291 294, or they can email info@prialalegal.com.au. And of course, I'm going to upload all these segments on YouTube this weekend.
Beautiful. Thank you so much, Despina and Wayne.
Bye.